Uh, Thank you all for coming today. Today we're going to be talking about IP, and in particular, we'll be talking about IP as it relates to due diligence for investment. Now, we do have a number of slides here, but we want this to be more of a discussion, so feel free to interrupt us and ask questions if you like. No problem if we don't get through all the slides. This is a good opportunity for you because Sabrina and I are both IP attorneys, and you can ask us questions, but obviously there's no billing rates or invoices or anything involved here. So feel free to ask any questions you like, and we'll be around after the presentation for more questions. And then we also have a little table or booth right over by the bar downstairs on the first floor. So feel free to grab a drink and stop by to talk about IP. Okay. So my name is Dave Schmidt. I work at a law firm called Knobbe Martens. It's spelled Knobbe, but it's actually pronounced Knobbe. Knobbe Martens is one of the biggest intellectual property law firms in the United States, and we are a boutique firm because we only do intellectual property. So we do intellectual property and trademarks, patents, copyrights, trade secrets, etc. And we do both IP litigation and prosecution. Now, the reason we're here at this particular conference is because our firm has a very heavy emphasis on medtech. About half of our practitioners all do work in the medtech space, and we have about 300 or so practitioners. And in fact, over the past 5 to 10 years, we filed more patent applications in the medtech space than any other firm out there in the U.S. So definitely a lot of expertise in that area. For me in particular, most of my work is in the medtech space and also in the pharma space. I have a PhD in biomedical engineering, and then one of my master's degrees is in pharmaceuticals. So I do work all the way across the board in med device. And in particular, I represent a large number of investors who invest in smaller med device companies, and then also the flip side, companies that are looking for investment. So I'll turn it over to Sabrina.
Hello, my name is Sabrina Wang. I'm also an IP attorney at Knobbe Martens. I've been at Knobbe Martens for the last 10 years, and my practice also emphasizes heavily on medtech. I have a background in biomedical engineering. I actually went to undergrad in National University of Singapore, so I'm really happy to be back here.
Hi, folks. My name is Varun. My background is actually software engineering and electrical engineering, but I am managing director at Chaanakya Capital, where we invest in early stage neurotech startups. So quite within the medtech space. And I really thank David and Sabrina for inviting me here on their panel.
Okay. Come on. There we go. All right, so I'll just briefly touch on some of the different types of intellectual property, but I'm hoping you have some kind of a background in this area. So the four main areas of intellectual property are trade secrets and patents, trademarks, and copyrights. It's really, though, trade secrets and patents are the ones that are kind of relevant for medtech type diligence. Trade secrets refer to something that is kept secret by your company and that has some kind of an economic value. Those are the only two prongs that make it a trade secret. So it could be something from a manufacturing process that you want to keep secret, that's sort of the special sauce for your product. Or it could be something like a list that has a number of vendors or things like that has economic value to you and you want to keep secret. Trade secrets often do come up in medtech diligence. In fact, I've seen it become more relevant recently, and that investors seem to focus more on trade secrets. It really just depends where your protection lies. So if your company has more protection in the patent space versus the trade secret, then maybe the focus is on patents. But if it's more in trade secret, then the focus could be there. Trademarks usually aren't a deal breaker in the medtech space. I think that's more for other industries. Same with copyrights. Copyrights cover things like that cover creative expression, for example, videos, music, poems, things like that. Doesn't come up that often in medtech, except occasionally with software.
I'll just add, I have filed copyright on a head which my client has developed for training injection techniques.
Okay. All right. So I guess I'll turn this to you, Varun. We've got a quiz. So I have a patent on my device. Does that mean that I have freedom to operate? True or false?
My true answer? False.
False. Correct. That's right.
Thought I had to give the wrong answer first.
Yeah, that's right. So this is a common misconception in the industry, is that you have a patent on a product and you think, oh, that means that I can go out there and I can sell that product without any potential repercussions. But that's actually not the case. What a patent gives you is a patent gives you the right to exclude others. It doesn't necessarily give you the right to practice that particular patent. To practice that particular invention. So what that means is that you might have a patent that covers some particular feature of your invention, but then when you try to sell that invention, there's other features of that invention that might run into other patents, or there might be broader patents that can still read on that particular invention. So it's very important to, even beyond getting patent protection for an invention, to also understand the landscape of patents that are out there that could potentially block an invention. Okay, so now turning a bigger picture wise to IP diligence. When we're looking at IP diligence, there are sort of three big buckets that we look at. When I'm doing IP due diligence, I've got a series of pages of different questions, but these are sort of the main buckets. So one is, do you own your IP? Two is, how strong are your patents and or your trade secret protection? And then three is, do you have freedom to operate? So I'll turn over to Varun. Of these three factors, which one do you usually see as being the most important? And then how do they fit into your valuation of the IP for a company?
Yeah, probably hard to just give a short, quick answer, but I think freedom to operate, my personal preference tends to be that way because, like you said, just having an IP or a patent doesn't necessarily mean anything because venture capital, we are looking at commercialization pathways.
Mm-hmm.
We want to understand that, hey, look, we can start commercializing in some way and build on top of it and so on. So for me, and from whatever I've seen, freedom to operate comes pretty high, especially at these stages that we are operating at, the pre-seed and so on, right? Of course, as you go on to advanced stages, Series A, B, and so on, it becomes more and more complicated. But by that time, the freedom to operate should have been very clear. And then the strength of the patent next, and then the ownership. Again, my perspective, because early stage, often the startups come to us from university incubations, but there is a tech transfer and all those kind of things that are involved. So sometimes we're willing to understand those, so long as there's a pathway. But I'll just pause there if that makes sense.
Yeah, I agree with you. I think that freedom to operate is often the factor that investors are focused on the most. Nobody wants to buy a lawsuit, right? You don't want to invest in a company and then immediately get sued. So freedom to operate is very important to figure that out. Now, what often happens, particularly with early stage companies, is that they haven't even done freedom to operate yet. And so oftentimes the investor has to come in and they have to make the decision there. Do they want to go ahead and do their own freedom to operate analysis or rely on what the other company has done before, or just go ahead and make the investment and hope that nothing bad happens. So that can really depend on the level of investment and the sophistication of the parties involved.
I've come across cases where, the investor would do some early stage FTO, and then they would, in the closing agreement with the target, they would say the target would have to do a full-blown FTO after funding.
Yeah.
Have you done that, Varun?
No, not in whatever I have been exposed to so far.
Okay, moving on.
All right.
Sabrina.
The next quiz question. So I have filed a patent application. I, as in the company. So the company must own the IP. Is that true or false? Anybody in the audience? I see people shaking heads. All right. You're correct. It's false. Because it's not always the case. Next slide. So in the U.S. and in many other countries, the IP rights typically automatically vest with the inventors, and the companies that hire these inventors will have to have a proper documentation to show that the rights have been conveyed by the inventors to the companies. So there are, because of that, startup companies typically don't pay close attention. Maybe when they enter into agreements with either their employees or consultants and vendors, where there are intellectual property related clauses in those agreements, but because those agreements in general was not IP in nature, they would not have an IP attorney take a look. And there's some languages there that are not clearly conveying the rights to the company itself, and those can create problems. And then, as Varun mentioned, the university license agreements. I think at the university level, that may not be that big of a concern, but sometimes the inventors themselves have are employees of the university, and when they create some inventions, the university might already have the rights. And even though they sign a document that says, I commit my rights to the company, but the university actually have superseding rights, those are also issues that we need to think about. And also, of course, there are trade secret protection programs that companies typically need to set up to make sure that they properly protect their mostly technical know-hows in the startup company. And also when talking to collaborate with other companies, or maybe in the example of a startup company, when talking to surgeons or doctors, whether a proper NDA was in place to protect IP. And then I'll just speed up. In the later stage companies, there are also similar concerns like ex-employees diligence, new employee onboarding training, trade secret compliance, and reminder of obligations during exit interviews.
Yeah, we sometimes see with very early stage companies that when they're just in there messing around, making inventions, they don't necessarily get all the agreements in place for the ownership. The way that legally it works in the US and in many other countries around the world is that the inventor initially gets the assigned inventions. The inventor initially owns the invention, and then at some point they have to then transfer it to another party, or there needs to be some other agreement in place. So we've certainly seen many times that these early stage companies, they don't necessarily get all the agreements in place. They don't think about that kind of stuff. And then later on, when you're going through diligence and we start really investigating those issues, you'll find that, the company doesn't actually own the IP, or this person owns a piece of this IP, and we don't know. So these are all things to think about, before you go into actual diligence.
All right. And I have a quick war story to share about messy agreements. So the startup company, who was once my client, had formed a series of offshore companies for tax benefits. And when creating those companies and transferring all the IPs, they thought they had a clean chain of title, but when you look at the schedule, and there are several key patents that were left out in the schedule, and we will have to go find a person who is an officer of that offshore company in order to perfect the title, and those companies have been dissolved a long time ago. And so how do you find even an officer who could sign those documents? It was a big challenge. Luckily, we found those people, and then we could backdate assignments to, before the company dissolved. But it would have been much cleaner if the IP attorney properly looked at all the assignments as the companies were getting formed or dissolved.
Varun, do you have any examples of when you've run into this where the IP just hasn't been properly assigned and the ownership is unclear?
Actually, I was going to ask you a question on behalf of the audience, but let's do this one first. Yes. So I think recently we were diligencing, we sent this about a year and a half ago.
Mm-hmm.
I had not encountered until that time this kind of a thing where I think it seemed to me like the entity, actually there were two examples. So anyway, one entity it seemed like a lifestyle startup, kind of lifestyle company, or what do you call that? They basically were trying to spin off different companies. The parent still held all these C-level folks, and they would lend or loan a one of the execs to this new company. And they were looking for funding. And we're like, okay, well, so you have a clear thing, that company owns this?
Mm-hmm.
Yeah, we also have these persons involved in that one. And we're like, so are these persons going to be transferred to that company? No, not now. It's about 50-50 as needed. We'll just lend them and they come back. Okay, so at that point, if somebody wants to buy the company or there's an exit potential, how are you going to do this? So it was not at all clear.
Mm-hmm.
We passed.
Yeah.
That's as much as I can.
Probably the right call.
Yeah.
All right.
Next, a few more other reminders about agreements that could really trip up your IP rights. Actually, we have already covered those. And some other issues that come up with agreements, particularly when you do vendors and third parties, in addition to making sure that your IP rights are properly protected, any work product or inventions coming out of any projects that the vendors and the third parties are performing, it should belong to the company. And then if you're really working with just one vendor who already has all the know-hows and is not, it used to be typical that the know-hows would automatically belong to the company, but it seems like these days some vendors really like to just take it because they could, make the same thing for another company, or maybe they can do their own thing. We have certainly had clients in our firm whose vendor took their invention and started their own company, and it went into a big trade secret misappropriation lawsuit. And then there are other things like assignability and other issues that are, at first glance, they're not really IP related, but if you think about it, it really becomes an IP rights issue. So the bottom line is check with the attorneys before you sign anything.
Yeah, this is an important pitfall to note because we've seen it multiple times. You need to keep track of your vendors. So we've seen on a number of occasions where you'll have a smaller company or a startup, you'll go to a vendor and the vendor is making a product for you, or maybe making your materials, making your raw materials, and you're sharing information with that particular vendor. We have seen occasions where that particular vendor has just gone out and then filed a patent on exactly that. And so that's one of the questions that will come up in diligence. And if you're a small startup company, you're working with particular vendors, you need to take a look and see what they're actually filing, because there's always a chance that they might be filing on what you're working on, and that could be a real problem.
I actually have a question because this is something that we see a lot of startups approach us and they already have vendors, co-vendor suppliers and so on. What is a good way? So in this particular example you talked about, is there a way to prevent those vendors from doing that? Because the whole job is the vendor does this for me as a startup and I'm owning everything else. So how do I prevent them? Like, is there a way for me to track that?
Oh, yeah. I mean, the way to prevent it is in the agreement you have with the vendor. But the problem is that there's sort of a disparity of power sometimes, right? So when it's a small startup company, they're trying to get a vendor to help them out. They might even need to get R&D help from that vendor. And so they're maybe not sophisticated enough to get the right terms in the agreement, or they might feel like there's a power imbalance and they have to agree to terms that are favorable to the vendor. I mean, really what you should have is you should have an ironclad agreement that is going to make it clear that IP that's co-developed with the vendor is going to belong to the startup company. But that doesn't always happen, particularly with smaller companies that are less sophisticated. Yeah. And these are all the kind of things that just come up in diligence. Then you have to talk about them. Okay.
Right. Next question. So I have a patent, so my device must be protected by the patent. True or false?
I think Varun. Oh.
I think people should start seeing the trend. Everything is false.
Everything's false. Yeah, they're all false.
I was going to say, just the trend.
Yeah. So depending on the stage of a company, there are a lot of different patent strategies that are at play, and when we talk about early stage company, typically one that's not even that's pre-revenue, you only have so much IP budget to just file a handful of patent applications just to cover your core IP, and sometimes you really want to get the patents quickly, for funding purposes or for exit strategy, and you try to take advantage of some fast track programs in various patent offices. For example, the fast track program in the US, or that patent prosecution highway if you file a PCT application. But as you move to a mid-stage level where, for example, when you started generating revenues from your products, then you started to make sure that you not only file patents on core technology in the US, but you start thinking about filing internationally and have multiple continuations pending, particularly in the US, where continuation practice is a little bit more friendly. Not so much anymore today because of new patent office fee rules. But overall, the general idea is you're going to try to create pickets and fences. Think about what Dave mentioned, that patent is a right to exclude. So visually, just think about them as building fences or moats around your core technology, and not just even the product itself, but how you make it, method of manufacturing, method of use, any software, user interface, anything that could set your product apart from other similar products on the market. And then for even bigger companies at a commercial stage where you're like generating a lot of revenue from your various products, then you really have to be strategic in important global markets and continue building that patent thicket.
Okay.
And next question. My device has been around for decades, so there's no way for me to get patent on this improved device. Is that correct?
False.
False. Yes.
Yeah, that's an easy one. It's true, and don't be discouraged if you're entering a market where it looks really crowded. There's a lot of prior art out there. For example, we're just using a very simple stent example here. Maybe someone who invented stent, that was a very long time ago. This thing is definitely in the public domain and it count as prior art. PA stands for prior art. And then a little bit later, someone made an improvement on the stent. So now it's a particular material, a nickel titanium stent, which is patent number 2. And maybe that becomes old, and then someone added another improvement, which is covered nickel titanium stent, which becomes patent number 3. And then a little bit later, another person made another improvement, which is drug eluting from that improved patent number 3. Then it could become your patent. So everyone is just building little incremental improvements on medical devices, and you can certainly still find patent protection for your devices or method of using it or method of manufacturing, whatnot.
Yeah, I think the lesson here is that even in a crowded space, incremental improvements may still be patentable, and small incremental improvements can be extraordinarily valuable, particularly if there's something that you've patented more recently and you've got 20 years of term. It could allow you to capture the market. So even though the space is a little bit crowded, don't be completely discouraged there's too much out there, because there's often gaps where improvements can still be captured.
I have a question, actually.
Yeah.
Question, and pardon my engineering hat at this point.
Oh, no worries.
But, let's talk about your patent part of it, right? So drug eluting, covered. So the first term is, for me, the differentiator, right?
Mhm.
Actually, I mean, it's on top of the foundation. So let's say there's another company simultaneously, let's call it disintegrating covered nickel. So everything else on the foundation up to patent 3 is the same. And just the first term is where mine and another company's differs. How does it work? I mean, is the net value just the incremental? How is it treated when you look at distinction?
Well, if you look in terms of patent infringement, so you just have to meet every single limitation. So potentially if patent number 3 is still in force and it's owned by another party, it might cover both theoretical company A and theoretical company B. But if theoretical company A, right, they've gone in a different direction from company B, then they might get protection for using that stent that elutes drugs, has the nitinol base, and then uses whatever feature that they have. So they might have protection in that area, whereas the other company B would have protection in the further area, but neither A nor B might actually be infringing each other, right? Because they have limitations that would not be covered by the product from the other company.
Right. So in the freedom to operate exercise, you saw the other company's patent, you check the mark and say, I am missing that particular element. So that one is not a risk for me. Yeah. So building off of the previous slide, but talking about when you have an invention and you don't realize it, many of you here are really smart engineers, PhDs, doctors, and the issue sometimes with people who are really smart is they think everything is obvious. But to get a patent, typical 3 standards, it needs to be new. It needs to be something identical must not have been around before. That is not a very high bar. And it needs to be useful, which is also not a very high bar, but it also needs to be non-obvious over what is already in the public. It typically comes up when you're trying to solve a problem that came up in your engineering job, and then the smart engineer thinks, oh yeah, I know how to do this. It'll just be this way. Oh, this is so obvious. There's no way I could get patent on that. I hear that from clients all the time, and you have to tell them, please tell me when you're solving a problem, because that could be valuable IP in how you solve that problem, or sometimes even in realizing there is a problem to be solved, which I mean, in the product development world, we just call it an unmet need. And we just provided a laundry list of all the possible ways, you can protect some new innovation. And the list is really non-exhaustive.
Okay.
Yep. And talking about what is already in the public domain, that is something that startup companies really need to, not just startup companies, many companies, and the engineering team and R&D team really need to be very careful of, is to not lose your rights by inadvertently disclosing your innovation to the public before you even file the patent application. The United States uniquely has a grace period. If you disclose something, you still have 1 year to file patent protection on that, but many countries don't have such a grace period, like China or Europe. Once you disclose it to the public, you lost patent rights. So a very important lesson is any time when the company is making some publications, like if you're submitting an abstract for a trade show or a journal article, posting something on social media, going on the trade show and showing your new device to the doctors or the focus group. We need to make sure that a patent application has already been filed before you make those disclosures. And another detail to when making those public disclosures is what we call academic humility. Is when someone publishes a journal article and says, well, these hypotheses have been validated in animal models, but we don't know if it works in humans. And then go ahead and file a patent application, and years down the road, there's an infringer, and the application is on human, and then the infringer will do anything scorched earth to find a way to say, I don't infringe your patent. And they're going to highlight that sentence that in the publication that says they said they don't know if this will work in human. How could they file a patent application on that? Similar to that, there's what we call lawsuit fodder. Like when you're talking to someone or writing an email and that says, this device works exactly like the other device that's already on the market. And those things could really come back and haunt people. Maybe we can just skip to the next one.
So Varun, in your work, have you ever come across this kind of a situation where a company has sort of accidentally destroyed some of their art, their patents or IP protection?
I think the most recent point about the academic humility, I did not know it by that term, but I think that is significant because yes, as scientists and technologists, I know my fund advisor is a scientist sitting on a startup idea. Maybe we should come to you, sitting on a startup idea and has actually held back on publication. So you're absolutely spot on. And I was like, why aren't you publishing? Well, if I publish it, it's all out there. Why would I do that? And I think, oh yeah, that's right. Right. So yes, it is. And to your point that one thing that, we may not, it may not work on humans is enough of a thing for somebody to come and challenge you. So yes, it's a day-to-day conversation that I have. I kid you not, with my fund advisor as well as some of the early stage founders that come to us. They say, yes, we are working on research. So one of the first things we do is like, okay, have you published everything? Well, no. Right. Okay, so hold on. So you need to talk to somebody and so on. So we point them to the right sources and so on. So yeah, we do.
Yeah, I mean, it's a big problem with academics, and we've run into this many, many times. There's just so much pressure to publish. You need to publish to get grants, things like that. But that publication, doing your duty to disclose to the world what you've been researching, it could potentially impact your patent rights later. So this is definitely something to think about. Think about the words that are going into those journal articles, those publications, and then think about whether they should be submitted at all, or if you should be getting patent protection first. So all things to think about. All right, so we're not going to ask this question. I asked this earlier, but we're going to circle back on FTO because, as we talked about earlier, FTO is usually the number one issue that investors are looking at when they're investigating whether to, acquire or invest in a medtech startup. And the reason for that is, again, nobody wants to buy a lawsuit. Nobody wants to have to buy a company and then automatically have to be licensing all these things. No one wants to try to enter in a marketplace and try to sell your product and then be told you can't even sell the product. So when you're evaluating FTO, you've got to consider these third-party patents because you can still be liable to a third-party patent even if you get a patent on some improved product. So we talked about earlier the improved stent. But for infringement, every single claim limitation must be present in your product. So this is the way to escape patents, right? Is you look at these patents and they'll often have a number of limitations because they have to overcome the prior art. And oftentimes there'll be a limitation in there that may not read on your particular invention. So for example, we talked about this earlier, but we have a drug-eluting covered nickel titanium stent. So it's got all these different features, right? But something like this could still potentially infringe on a patent that only has the drug-eluting stent, because the drug-eluting stent might not recite all these limitations, but the product itself might still read on just that drug-eluting stent piece. So potentially there's infringement risk. There's also potential risk if there's just the nickel titanium portion of the stent, because again, that's still in the product, even if you've improved on that. So lots of things to look out for out there, and it certainly does make sense to, for a small company to start looking at some of your major competitors first before you go into due diligence. And then if it's merited, if the size of the valuation is high enough, to maybe even do some of your own freedom to operate searching.
Yeah, sometimes it's a really uncomfortable conversation that we have to have with our clients when you show them a patent claim and say it has element ABC, and the client said, but I have this D that this is ABC doesn't have, and you have to tell them that's not how patent infringement works. That's how patentability works. That's how you get a patent.
So continuing along the lines of freedom to operate, actually I'll turn this to Varun. So what do you look for at different stages of a company in terms of their freedom to operate analysis?
So can you be more specific, maybe?
So for example, if we have a small company, maybe they've only got angel investment or maybe Series A or even earlier, our expectation for them would be that they haven't done a full FTO, but maybe they've at least looked at some of their main competitors. From your perspective, what should they have done by that stage?
Yeah, I think first of all, I think we, by virtue of going at it through a commercialization aspect, again, from our fund's perspective, we're trying to look at, is the technology unique at a very high level? And that itself gives us some indication of what are the kind of things we may want to look at in terms of IP, right? The number of pitches that I get in this field, often if the technology is not deep enough, it's very easy to say, okay, it's kind of borderline. I can expect it's a kind of a repeat or not much of an innovation. So then it's a go, no go that I decide right then and there. But often it's deeper tech. Mm-hmm. And by virtue of that, I would expect that it is already past a lot of these kind of checks of like, hey, it's strong, technically strong patent, basically. Freedom to operate wise, I think so far, at least for our fund, we've been looking at non-existent incumbents. I don't know if that makes sense. Like the solution doesn't exist, or it's a completely different, like a pharmaceutical solution. Mm-hmm. So for us, it becomes easier to then look and say, okay, well, it is kind of doable. I think I'm in the ballparks there, but that's why I was asking for a more specific case. But yeah, this typically has been my experience so far.
Makes sense. Yeah, for a mid-stage company, investors would expect a little bit more on the FTO front. So if you've already gone through, you've gotten Series B, maybe tens of millions of dollars investment. At that point, they'd be looking for you to have done more of an FTO analysis of the marketplace and have a better understanding of what's out there, whether there are risky patents that might need to be licensed or acquired. And then at a later stage, you'd want to be able to demonstrate low risk of infringement for all aspects of the commercial product, possibly internationally. And at that point, you can start to think about whether, if there are some problem patents out there, things that you can't necessarily get around, looking at lawsuits or invalidation, some other routes like that. But okay, but that's the end of our talk here. So if you have any questions, we've got a few more minutes left. Oh, thank you. All right, Varun, did you have any questions?
I had one.
Okay.
Maybe you probably have to go back to some of the slides. I forget, but I think I'll turn it back to you for just a bit, right? As investors or as startups and investors having these early conversations, right? Somebody who's coming from a university incubator, for example, what are some guidelines that we as investors can give them, especially with freedom to operate? Because that's the number one. Like, you're right. So now, what are the key landmines that we should point them towards to say, hey, this is it? And that's an answer that will help me as well, but also help the startup founders think about the strategy going forward.
Yeah, well, I think a full-blown FTO can be quite expensive, and it's very resource intensive. So you've got to pay some kind of a searching company to actually do the searching and analysis, and those can run over $10,000 depending on the complexity of the search. But then, of course, you've got to analyze all the hits that come back. And sometimes there can be hundreds and hundreds of hits, which can be a significant amount of attorney time for your lawyers, but then also internally, right? The founders of the company might have to work on those, and the engineers and such would have to help with the analysis. So it could be a significant investment for an early stage company. And then there's also some additional risk in that you've now become exposed to all of this prior art, which then, of course, means that it needs to be bundled up into what's called an information disclosure statement with the USPTO. So all these things need to be disclosed because now they've been exposed to all this prior art. So for early stage companies, we often advise you don't necessarily have to do a full-blown FTO. It's not necessarily expected at that stage, particularly when the numbers are fairly low. But there is an expectation to understand some of the big players in your space. Right. So some of the bigger players that you're going to be up against in the marketplace at least have a general understanding of what kind of IP they have, and maybe even do an ASIC type search, would be looking at all of the IP that they have rather than doing a full-blown keyword type freedom to operate search.
A quick follow-up on that as well, right? So yes, that brings to mind another case or another example. So we talked about patents where you have a platform, an increment, and so on. And there comes a time when there are a few players in the market.
Yeah.
They're going about it differently. Maybe one is talking about ultrasound and the other one is talking about radio frequencies, electromagnetic signals. So physics-wise, yes, two different things. But at the end of it, they're trying to solve a problem. And that problem is the common part here. So now, how should they think about freedom to operate in this case? And early stage, so they're all equally early stage. So when we are doing the due diligence, we look and we easily find out, not from a patent perspective, but technology. Oh, this company is doing ultrasound, that one is doing radio frequencies, and so on and so forth. So we have narrowed it down to that point. Now, what should we look for? We as startup founders, we as investors, things like that.
I think for if it's a limited number of players in the field, even if the key technical differentiator is different, typically would still advise the startup company to set up a monitor, which actually is not expensive to do at all with some of the commercialized software. And for every one of the patents those key competitors are getting, you would always want to check whether the claims would include that key differentiator that you don't have in your device. As long as you don't, then and from a third-party risk perspective, you don't have that. It usually, especially in the US, where they can go to the 10th continuation application, that's when the claims get broader and broader and broader, and to the point where it's just solving a problem without actually saying how you solve it. I anticipate that's when you get nervous with, the players is solving that problem, even though with a different technology.
Yeah.
Okay, makes sense. Oh, sorry. We asked a question. Was that 2 minutes? Okay, yeah. Okay. Well, any other questions out there? Otherwise, oh yeah. Yes.
Like if you're operating between different jurisdictions, where do you file?
And we get that question a lot.
Yeah.
Where do you file? I think our home country is a no-brainer. You always want to file there. And then the next question is, where do you file internationally? And it's a budget issue, and it's also an issue of where do you see yourself commercializing that product in those countries, where your key competitors are coming out of, and your key competitors, where are they filing patent protection for? And also, if it's a fairly early stage company, you also want to think who are my potential acquirers or investors, and where would they be interested to see patent protections? Some of the key points to think about.
Yeah, there's also this aspect of maybe kicking the can down the road a little bit. So there is the Patent Cooperation Treaty, which gives you the opportunity to file, an international patent. But you don't have to actually enter countries immediately. It can sit there for up to 30 months before it actually has to enter into another country. So that's a way, if you've got limited funds, you don't necessarily know where to file yet, but you're starting to go through investment rounds, get that PCT filed. And then now you can tell your potential investor, hey, look, I haven't gone to these countries yet, but I can go anywhere I want. I've got this option right here to take it to any country that is of interest to you.
Right. Many times investors and acquirers want to see flexibility in your patent protection. You don't have to have done it very well, but as long as you have left the option open for them to later on fix it, then it's usually fine.
Okay, I think we're done. So thank you everybody for your time. Appreciate it. We'll be at our table on the first floor if you want to stop by and talk IP. Thank you for your time.